and welcome to the February edition of HR Hot Topics. I'm your host, Jodischafer, and my aim is to make this the most informative 5 minutes of your month. This month, I think we will actually be close to that for the first time in a long time. I want to bring you a recent update from the Department of Labor. For those of you that have been watching these updates for a number of months or even years, you'll know that I have hinted towards the Department of Labor taking a look at the independent contractor rules. In other words, what are the criteria that an individual needs to meet in order to be considered independent? In other words, not eligible for overtime, not eligible for minimum wage, not technically a W-2 employee. And the Department of Labor took a look at the rules that were in place. This was back in 2021. And said, hey, I think we need to make this test a little bit more streamlined, and we really should just look at two key factors here, the ability for the independent contractor to have profit and loss, and how much control the employer has over the working situation. And that was all well and good. So for the past 3 years or so, that's the rule we've been operating under until now. So the Department of Labor took another look at the language and said, actually, you know what, we want to reinterpret that. We think there need to be more criteria. It's a little too simplistic in nature. And so they proposed a new rule that was in place for a number of months. The proposed language, we could all take a look at it and give our public comment. And so now the Department of Labor has recently come out with the finalized language around this, which will become effective on March 11th. So it's coming up. So the new language, the reinterpreted rule, now looks at 6 factors. So this is almost a throwback to how things were pre-2021. So this isn't totally revolutionary, but it certainly doesn't bring any clarity to this issue. In fact, I think it continues to muddy the waters for employers, and I think it's really inflexible for folks that want to be an independent contractor or employers that want to hire independent contractors. So I feel like we're losing on 2 fronts here. The 6 factors are the degree to which the employer controls how the work is done. That was always sort of implied. The worker's opportunity for profit and loss. Again, that was in place even up through now. The amount of skill and initiative required for the work. The degree of permanence of the working relationship. The worker's investment in equipment or materials related for the task. Again, that one's not necessarily new. And then this one, the extent to which the service rendered is an integral part of the employer's business. That is the one that is really going to be a hang-up for folks, employers that are using independent contractors now. And I want you to think specifically about the gig economy. Think about apps like DoorDash and Uber and Lyft. All of those folks, might now currently be considered independent contractors. And the folks working for those apps really like that. They like the flexibility. They're not required to work certain hours. They can kind of pop in, pop out. They have a lot of control over that. And now, under this new Department of Labor interpretation of independent contractor rules, that would become a really challenging position for those employers to maintain, the fact that those gig workers are in fact independent, especially because of that last criteria, the extent to which the service rendered is an integral part of the employer's business. That's going to hit a lot of us. And I think about my clients that are in the creative services industry that use freelance writers, right? Copywriters, freelance designers, freelance videographers. Well, if those are services that you're providing to your clients, it's a part of your business, does that become more difficult then to defend an independent contractor relationship? So the expectation here from many of the attorneys that have weighed in, and I'm going to link to some articles, you can kind of read the back and forth, but I think the consensus across the board is this will absolutely be challenged in court. And it's through court decisions that employers will truly learn how we're supposed to view an independent relationship. Some pieces of advice between now and then. I think it's a really good idea to take a look at your contracts. Excuse me. Take a look at any contracts you have right now with independent contractors. And as you know, is there even a contract in place? Is there a written document in place that really clarifies the nature of the relationship, clarifies things around who pays for tools and resources to do the work, clarifies things around who's going to pay taxes and carry insurance, et cetera. If you don't have a document like that in place currently, and you are using independent contractors for some of the work that you perform, it would be a good idea to develop something like that. Now, I have those in place for the consultants that work with me. I did not write that by myself. I paid an attorney who is much more informed about the ins and outs of this than I am. Again, it's a very difficult standard to meet. It's not really clear. And so I had an attorney help me draft that document. I have those in place with all of my independent contractors. It would be smart to take a look at what you have in place as well. But just be prepared that there seems to be momentum building to make this independent contractor category very, very narrow in scope. California has an ABC test, and the C component of the test is exactly this last piece of criteria. Is the work that the independent contractor is doing for you integral to your business? In California, if the answer to that is yes, then they are not an independent contractor. Even if they have control over their working hours, even if they're paying for their own tools and computers and resources, still a no-go. You have to meet all three in California. And there's some chatter about whether or not Michigan's moving in that direction too. So it looks like at the federal level, Department of Labor is trying to bring back kind of an old thought on this. Now we've got 6 criteria to look at. The IRS had a 20-factor test, so it's still a challenging place for employers to be. Not a lot of clarity here with this new proposed final rule. It's final now with a March 11th effective date, but wanted to make sure you were all well aware of that. If you're using independent contractors in your business, you're going to want to check out the links below this article so you can read up on some of the language of the rule, some articles, and of course some resources to help you with compliance. If you have any questions, you can reach me directly, Jodischafer at workwithhrm.com.